नमस्कार दोस्तों, वेलकम टू आवर Shorthand Lab Prayagraj channel. Legal Dictation, 5 seconds remaining. Start. The criminal complaint under section 5 bracket 4 read with sections 5 bracket 2 and 3 of the Official Secrets Act 1923 hereinafter called the Act was filed against the petitioner in the Court of Chief Metropolitan Magistrate, Delhi by the Union of India through Deputy Superintendent of Police, Central Bureau of Investigation, SPE, Anti-Corruption Unit, New Delhi, full stop. The petitioner filed an application under section 245 of the Code of Criminal Procedure in the trial court for being discharged on the grounds that the order of the prosecution had not been passed by an appropriate authority and that the cognizance could not have been taken as, according to him, the complaint was barred by limitation, full stop. The magistrate rejected the application by his order dated 17/3/1995 and the revision filed in the High Court was dismissed, while the order impugned in this appeal, full stop. Relying on the provisions of section 13 bracket 3 of the Act, the trial magistrate as well as the High Court held that section 13 bracket 3 of the Act provided the taking of previous consent or sanction of the appropriate government and the time required for obtaining such consent or sanction was to be excluded in terms of section 470 bracket 3 of the Code of Criminal Procedure, full stop. It may be noticed at this stage that limitation in the instant case is stated to have started from 24th April 1985 and the complaint was filed in the court on 19th May 1988, apparently beyond 25 days of the period of limitation prescribed, full stop. The plea of the complainant was that period of 79 days required for obtaining the sanction order should be excluded in computing the period of limitation, full stop. Pointed reference was made to the order of sanction dated 21st April 1988, copy of which has been placed on the paper book of this appeal, full stop. Accepting the plea of the complainant, the complaint filed against the petitioner was held to be within time, full stop, paragraph. Mr. Vijay Bahuguna, senior advocate appearing for the petitioner, submitted that as no sanction or consent was provided to be taken from the government under section 13 bracket 3 of the Act, the complaint admittedly filed after the period of limitation was required to be dismissed and the accused discharged in terms of section 245 days of the Code of Criminal Procedure, full stop. He did not urge any other point, full stop. In support of his contention, he has relied upon the judgment of this court in Electrical Manufacturing Co. Limited versus D.D. Bhargava 1968 bracket 1 SCR 394, Sri Kirat N. Rawal, Learned Additional Solicitor General, defending the impugned judgment, has submitted that the judgment relied upon is distinguishable as to the mandate of section 13 bracket 3 is clear and unambiguous, providing the obtaining of sanction before filing the complaint, full stop. He drew our attention towards the averments made in the petition and the order of sanction to urge that even if no sanction was required, the complaint be deemed to have been filed within time as the complainant and the other officials bona fidely believed that such a sanction was necessary before the filing of the complaint, full stop. Thank you so much.